our special focus at this hour. The Supreme Court has held that children from quote-unquote invalid marriages are entitled to a share of their parents' property. This is what the Supreme Court has said. And it has also said that they will not be entitled to any other property except their parents. But it's a welcome move given the fact that now these children who are from void and voidable marriages under the ownership law in the Hindu succession law will now have a share in their parents' property. Earlier, there were many court judgments, in fact, that were against it, saying that they are not entitled to their ancestors' property. But now the Supreme Court has overturned those earlier court judgments. They're saying that, well, these children and their rights are independent of their parents' relationship. An extremely progressive and welcome move there. And joining us, a very special guest, Shirish Deshpande, an advocate. He's with us to, in a sense, decode the Supreme Court's order. So many thanks for joining us on NDTV. It's a very welcome move. We'll come to, in a sense, analyzing how progressive that is. But first, break it down for us. How will these children be able to claim a share in their parents' property? And there are many pending cases in this regard as well. How will it be implemented?
Yeah, this is a very benchmark decision of the Honorable Supreme Court of India. Section 16.1 speaks of the void marriages. And section 16.2 speaks about the voidable marriage. So there is a non-obstant clause which says that irrespective of void and voidable marriages, the children who are born out of these marriages are entitled to claim the property rights, which is enshrined in the section 16 subsection 3.
Right. Absolutely. And as I said earlier as well, it's an extremely welcome move because the Supreme Court has also sent out a larger message that these children and their rights are independent of what their parents' relationship is. So, is that something that needs to be extended to other rights as well? There are certain fundamental rights that all children, whether they are, children from, as they say, invalid marriages or lived-in relationships, their rights should remain intact, isn't it?
Exactly. But we have to go by the spirit of law. The letter and spirit which is enshrined, which is posed in section 16 subsection 3, it speaks that the children should not be misbranded. The aim and object of the Amending Act of 1976, by virtue of which subsection 3 was inserted in section 16, is that despite the marriage being void or voidable, the legitimacy of the children should not be affected. So that is why the property rights which are given to the such offspring, so son and daughters out of void and voidable marriages, they are being protected. Therefore, it says other than parents.
And that's a very important point you made, that their legitimacy is something that the Supreme Court has, in a sense, sanctioned. So till now, because this decision was not in place, how is it playing out? Because, there are many children who, from quote-unquote invalid marriages. For them, it's extremely difficult. These are long legal battles that they have to fight to, in a sense, claim a share of their parents' property. How is it? How have you seen, as an advocate, how have you seen this playing out?
You kindly see in para 54 of the judgment, there are 10 clauses which are 10 grounds which are substantiated by the Honorable Supreme Court. Though the marriages are void or voidable, there is no need to, in fact, the provision speaks that there should be a decree of the court. Either there should be a decree of nullity, which has to be sought in respect of void or voidable marriages.
Right.
But the language or the opening language of the section 16.1, 16.2, as I said right now, it says that irrespective of that declaration or irrespective of the decree, whether the decree is sought either or not, the children...
And, that's an extremely technical bit. And very quickly, if you could just explain, how does this actually work? How does this joint family property ownership, how does this actually work under the Hindu law?
Actually, what has happened, section 6, in 2005, the co-custody rights were enlarged.
Right.
By virtue of, for example, daughter's right has been enlarged by the virtue of section 6 exception and 2005 amendment, which has been recently broadened by the Honorable Supreme Court judgment in Vinita Sharma. Alike, the status of that, the broadened scope is already given to these children who are born out of void and voidable marriages by virtue of section 16.3.
Right.
So the
Supreme Court, in a sense, is batting for reform as far as the co-parsonary property is concerned, as far as the Hindu law is concerned. An extremely welcome step there. Thanks very much, sir, for joining us.